Good afternoon. This is the House Judiciary Committee. It is the 3rd of April, 2025. We have some bills, a couple bills that are looking for concurrences or lack thereof. And we'll start with the lack thereof. Senate Bill 46. Senator Watson's bill on wrongful detainer. The Senate refused to concur in the House amendments. Bad judgment. And asked us to recede. We're not, the chair would make a motion not to recede. Second. And second, ooh, okay. All right, with an exclamation point, Delegate Arakan.
Thank you, Mr. Chair. Can you just tell me what the contentious point was again?
Can you speak to this, Delegate Williams?
Sorry, take your time. Yeah.
So the Senate bill has a trial within 4 to 7 days of filing a complaint, which violates due process because it doesn't necessarily require that someone has received service by that time frame.
Oh.
That's a little bit of a problem. Just a thought. Reduces the appeal period from 10 to 4 days, which is also a problem. Due process again. Plaintiff doesn't even have to name the defendant. It can be John Doe.
Oh, because they don't know, because it can be, can it be
Violates
like
due process.
Can it be a squatter where they don't know the name?
That's a possibility, but again, we are taking someone to court. We don't know their name. There's some due process concerns by that. And so, I mean, I can go on and on, but those are some of the main reasons why we're not concurring.
And so what do we switch it to?
So we have the trial within 14 days of filing the complaint to, again, give time for service and for the defendant to actually know he has a court date and needs to show up somewhere by a specific date and time.
Yeah.
The appeal process is just the current appeal process, so they could file their appeal, you know, after the judgment's been entered by the district court. They would still keep that. They do have to name the defendant in their complaint if they know their name. The House bill requires service of the complaint within 4 days of filing, so it just truncate the time frame for service, but at least there is a service requirement in there. And again, same thing, the plaintiff must have to prove their case, just like we would do in any other civil proceedings, so.
Okay, so the biggest differentiation is a 10-day, we're fighting over 10 days, basically?
It's about the time frame of the trial as well as the service.
Oh, the time frame of the trial.
Right.
Okay. Oh, yeah, the 10, yeah, so they wanted 4 to 7, and we're saying 14?
Correct.
Okay.
Are there any other questions? All right, the motion is not to concur. All in favor of not concurring, please raise your hands. Okay. Anybody opposed? One. All right, motion's not to concur. The conference committee, Williams as the chair, Schmidt and Phillips. All right.
Were you listening? Because he's looking like.
Oh, I warned Phillips ahead of time.
Okay,
Make a motion to concur right now.
okay, I couldn't tell.
Okay? Okay. Go on here. House Bill 853.
Not to concur.
I'm sorry, what did you say? I believe that there is a motion to concur in the Senate's amendment to House Bill 853. They just passed the bill. It would exclude further someone who was convicted of murder involving a victim who is a first responder, as defined in the Health General article, who was killed in the line of duty. There's a motion to concur and a second. I just did it in front of the room. All right. Are there questions with regard to this? There's a motion and a second. Any statements regarding this? Delegate Taylor.
Yeah. Can you explain the difference again, please?
Under the House version of the bill as it was sent to the Senate, it would include, the only people included were people who, it excluded life without parole, it included people who were going to be on the sex offender registry.
Right.
The Senate bill excludes people who are convicted of a murder involving a victim who was a first responder, who was killed in the line of duty as a first responder.
It's clarified further. I've seen them in it. Can you clarify for the good of the order, like, what they give as first responder?
So it's defined, and if I could have the Health General article for 18 in the Health General article, please. 18.213.2 of the Health General article, there is a definition of a first responder. The whole world going to look to see the book, and I will read it from the book. 18.213.2. A first responder means a firefighter, EMT, rescue squad member, law enforcement officer, correctional officer, or sworn member of the Maryland State Fire Marshal's Office.
My light's still on?
Yes.
Mr. Chair, do we know about how many people that are incarcerated now have these particular charges and
We
what the
don't.
population would be affected?
The educated guess would be somewhere 5 to 10. I think that the universe with these people taken out would be somewhere, my guess would be somewhere between 300 and 340. Because I thought it was 350 before, it's
Yeah.
somewhere in that ballpark. Delegate Pasteur.
I think you just said it. I just want to make sure in my delirium that I heard you correctly. So they have to be on duty.
They have to be killed in the line of duty. It has to be murder where that universe of people that the person was killed while they were in duty, on line of duty. All right, are there any other questions? All those in favor of the motion to concur, which has been seconded, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. The chair will vote aye on the motion to concur. All opposed to the motion to concur? 1, 2, 3, 4, 5, 6. Motion to concur is adopted and will go to the floor. So, all right. Now, let me talk about driving issues. So this is the, okay, so yesterday we had a bill from Delegate Wims, and there was a question raised with regard to the creation of what would have been another version of criminal negligence, and it caused some members of the community palpitations and concern. So to avoid that, we're having another conversation about it. We then did further research and discovered that the bill that was initially introduced by Delegate Grammer with regard to the must appear for reckless driving cases was actually folded into a bill that came out of E&T that we've all actually voted for. And so that has obviated the need to pass that or the Senate cross-file of that bill. And so now what we're left with at the moment is Delegate Schmidt's bill failing to remain at the scene of a boating accident. This is House Bill 676. There are amendments. Well, let's go, okay. I know we're all excited, but let's take it one step at a time. 676. We need to start with 123, which is Senator Simon Ayers' bill. So we're going to adopt, there are amendments to 123. This is 693422. So can you describe what those amendments do, please, Holly, and then we'll move on.
So these are just technical and clarifying. The amendments that you see in the reprint that Hunter sent out include everything that was done in the Senate. The only thing we had to add, and this was done in the subcommittee on the WIMS bill, but the part of it that was the voting components. If you look at page 3 and on page 4, there are provisions and sections that did not include a charge. So we just clean that up and say a person who violates is guilty of a misdemeanor and on conviction is. Right now, it doesn't say anything. The felony is included in different parts, but the misdemeanor was an oversight and it should be in there. So this is just a technical clarifying change on SB 123.
Any questions about the technical clarifying change? Delegate Grammer.
Mr. Chair, I just have a broader question about what happened with the bill. Should I save that after the amendment?
With what happened to the bill generally?
Well, my point.
To your bill? Let's wait and do this bill, because that bill, I think, has become obviated by, yeah, I'll get to that in a second. Questions about the amendments on 123? Seeing none. All in favor of the amendments to 123, raise your hands. Is anybody opposed? Seeing none, the amendments are adopted. We're on the bill as amended. There's a motion and a second on the bill as amended. Any further conversation about the bill as amended? Seeing none. The Vice Chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Stinnett? Yes. Congolo? Yes. Erican? Yes. And you can't add on to a Senate bill. You will in a minute. You will be able to in a minute. Taylor? Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? She's not here. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? All right. So now that takes us to House Bill 676. It has a questionable sponsor. We can't do that yet, though, because now we have to adopt conforming amendments to the Senate bill. There's a motion for the amendments in a second to conform 676 to look like Senate Bill 123. Does anybody have any questions or comments about that? Don't see anybody. All in favor of the conforming amendments, raise your hands. I guess. Anybody opposed? Seeing none. On the bill as amended. Motion for favorable on the bill as amended. It's do something. Okay. Well, in the context of amendments, if you wish to be added to this bill, please raise your hands as I look around the horseshoe. If you wish to be added, the Vice Chair, Valentine, Crutchfield, Tomlinson, Simmons, Phillips, Tolles, oh, I'm sorry, Tolles, Stinnett, Congolo, Erican, Taylor, Simpson, Grammer, Conaway, Kaufman, Williams. All right, any opposition to making the vote on Senate Bill 123 the same as the vote on House Bill 676? There's a motion. Any opposition? Going once? All right, the votes for 676 will be the same as the votes for Senate Bill 123, and we shall move on. We'll go on now to House Bill 828. Oh, I'm sorry. Before we go on again, the Environment and Transportation Committee moved a bill that effectively makes reckless driving a must appear, which addresses the issue that they had that was part of the bill, and does it without, in fact, the safeguards that we had already built in. So it's sort of moot at this point. I think that's right, yeah.
SB 598.
There's a jailable penalty is for one of they add a jailable penalty, which makes it a must appear anyway.
Expanded the definition.
Just say it on the record, so when we go back to these folks, we can tell them, look here, and this is how you're made whole. Can you
Yes. You're going to
articulate?
be able to say, we solved the problem, it's just on a different bill.
And can you clarify what part of the penalty of that bill does that for them?
A 60-day penalty would be a must appear. Any jailable penalty would make it a must
For which
appear.
offense?
For reckless.
Thank you.
All right.
Reckless driving is now expanded to include those who drive more than 30 miles per hour.
Right. Go ahead.
I just want to say for the record that noting that they did this, which I think is probably a good thing, but we should, in the interim, make sure that we communicate about particularly transportation and maybe health and government operations, creating additional penalties without being jointly assigned. It concerns me that because we're the committee that generally tracks this and makes sure there's consistencies in the law. When we don't do that, I think we wind up having to do corrections, and I just want to make sure that we're kind of all being chimed in.
Chair would broadly agree with that, and it's something that I think that we will be talking about a little bit in the interim, but here we are. And I need to move on to Senate Bill 828. It is, I'm sorry? There are committee amendments, and they are in your packet, and this is 353-326. And I believe that's correct, or am I wrong?
No, that's right.
That's right? Okay.
And the timestamp should be 239
The timestamp is 239
on your reprint.
on your reprint. Yes. So, Holly, if you would like to go through now what the amendments do to Senate Bill 828.
So
Please listen to council.
I'm just going to walk through all of the changes. The first changes that were made is the bill now includes House Bill 1222, which was the Maryland Values Act. It passed out of the House earlier this session. It requires, and you'll see those provisions, unfortunately, this doesn't have pages because it's been amended heavily, so you want to count and go to page, let's see, it starts on page 3 of the bill if you count the pages. And these provisions are also on page 5 if you count. And this requires, if requested by federal immigration authorities, an employee or agent of a state or local correctional facility or a law enforcement agent to provide notice of the release of a covered individual at least 48 hours before the release of the covered individual in order to facilitate the transfer. And to transfer the individual to federal immigration authorities, provided the transfer does not extend the covered individual's time in custody beyond the individual's scheduled release. It defines covered individual as it was defined in House Bill 1222, an individual who has an active immigration detainer and has been convicted on or before June 1st, 2025, of a crime of violence, any felony, using a firearm in the commission of a crime of violence under 4-204B of the criminal law article, driving under the influence or engaging in a criminal organizational activity, or has been issued an Interpol notice for criminal organizational activity. So you're going to see those again on page 3 and page 5 of the bill as it's been amended. The other part of 1222 that's in the bill is going to be on also page 5, if you count. This deals with the immigration agreements, also known as the 287G agreements. This prohibits the state or unit of local government, a county sheriff, any agency, officer, employee, or agent of the state or unit of local government from entering into an immigration enforcement agreement. And by July 1st, 2025, the state unit of local government, county sheriff, et cetera, has to terminate the agreement per the termination provision in the clause. This was all part of 1222 as it passed out of the House. So that is 1222, and that's in the bill. And then we discussed the sensitive locations provisions yesterday. I can cover those, but there were some changes since yesterday. If you count and go to page 4 of the bill, you'll see that in section 2-104.2, this is the warrant section, a public school, a public library was brought back into B2 because they are not included under the executive branch. And so we've brought those back into the bill. If you go now to, let's see, 1, 2, 3, 4, 5, 6, 7. Page 8 of the bill, you're going to see sensitive locations. Some of the definitions were altered. We put courthouse back into the bill. That was out yesterday. We've added a place of worship. And then we also added, in Roman numeral 7 of subsection A, Part D, access to justice. So now it says a sensitive location is also any other location that provides state-funded services related to physical or mental health, education, shelter care, or access to justice. We've added that in. And then the final changes are on page 10 of the bill. It's actually 5 at the top, but page 10. Subsection C was changed. And we amended that to now say private entities are encouraged to adopt policies consistent with the guidance developed by the Attorney General if the private entities provide services related to, and you're going to see the same, physical or mental health, education, shelter care, or access to justice. And then in subsection D, we just brought public school and public library back into that, that subsection. And those are the changes to the sensitive locations provisions.
Questions? Delegate Tolles.
Mr. Chair, Council, what is, and I apologize if you said it already. When you say access to justice, can you go into further detail what you mean by that?
Someone who goes to legal aid, someone who is, it may not be the courthouse that they're going to, but they're going to their lawyer's office.
Okay, isn't that already protected by?
Might not be. If their lawyer doesn't work in a courthouse, if the lawyer doesn't work in a public place.
No, I'm saying like if you have a lawyer, you're saying because it's a sensitive place, not
Right.
the information that's protected.
Right.
Okay,
Right.
thank you.
Delegate Grammer, then Conaway.
Thank you, Mr. Chair. So it sounds like this bill has provisions about the detainers, the sensitive places, which has been changed a little bit, and also includes language to prohibit the use of 287G and related memorandums.
The bill that we passed in House Bill 1222. So the bill, the portion that has to do with 287G is effectively, as I think I'm right in saying, apart from a change that we made to make it clear that they have to notify ICE at least 48 hours before. Everything else is the same as what was passed in that bill already.
Okay, so it includes the detainers. It also includes a prohibition on participation in 287G.
Includes the detainers.
The baseline requirement for local jurisdiction participation.
It includes the requirements that if they have been convicted of certain crimes, that they must give at least 48 hours of notice to immigration enforcement for them to come and pick up a person.
Correct. And it all, just for clarification, there are in this bill provisions which prohibit participation of jurisdictions in the 287G program or related memorandums.
As was in House Bill 1222.
All right, thank you.
Delegate Conaway.
Thank you, Mr. Chairman. Just want to be clear, this is going against, some portions of it is going against what ICE asked us about.
You know, I would argue that it keeps us in our lane and it puts federal workers in their lane, that ICE employees can find out when they have somebody who's been convicted of a crime, they can come and they can get them. Outside of that, local law enforcement, you know, needs to do their job working on local law enforcement. That's the idea here.
Thank you,
And
Mr.
then
Chairman.
writ large, the sensitive places portion of the bill addresses issues specific to you know what the rights and responsibilities are for people when ICE comes, in this case, as is in the bill, with a warrant for a specific person at a specific place. On the amendment, all those in favor of the committee amendments, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Anyone opposed to the committee's amendments? 1, 2, 3, 4, 5. 5. I see 5. So the amendments are adopted on the bill as amended. Any further discussion on the bill as amended? Delegate Phillips.
And I'm just curious as to, since the Senate didn't take this up, right? They didn't take up the 287G piece. Is that correct? Is that my understanding?
They have not yet taken it up. I think that we're kind of sending it back to say this is something that's an important issue that we think that needs to be addressed one way or the other, and we'll let the Senate address that issue. With regard to the sensitive places, I think this reflects a great deal of work that's been done with both the advocates, with the governor's office and others to address as many concerns as are out there. And so with that, we'll continue to be in contact with the Senate, see what they want to do at the end of the day, and watch this space. We'll see what happens.
All right. Thank you, Mr. Chair.
Yes. Seeing no further comments. The Vice Chair?
Yes.
Yes. Valentine?
No.
No. Crutchfield?
Yes.
Yes. Cardin? Yes. Yes. Tomlinson? No. Embry? Yes. Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Simmons? Yes. Boucher? No. Phillips? Yes. Stinnett? Yes. You cannot, it's a Senate bill. No. Nope. Valiant effort. Congolo? None. Arakan? No. Taylor? Yes. Simpson? Yes. Grammer? No. Sample Hughes? Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? Yes. Motion for a favorable has been adopted. We have one more bill, Senate Bill 80. Oh, Senate Bill 80. It is a bill of Senator Kramer's that has to do with animal abuse or neglect. There is a motion for a favorable and a second from the delegate from Senator Kramer's district. So, just noting for the record, so we've got a motion and a second, so let's hear from people. Delegate Valentine.
Thank you, Mr. Chair. Just since it's been a little bit of time, could you just explain what this bill does?
I'd be happy to.
Thank you.
It says you cannot commit a violation of 10604 of the criminal law article. 10604 of the criminal law article says that a person may not overdrive or overload an animal, deprive an animal of necessary sustenance, inflict unnecessary suffering or pain on an animal, cause, procure, or authorize an act prohibited under items 1, 2, or 3, which were the first 3 things I listed. Or if the person has charge or custody of an animal as owner or otherwise unnecessarily failed to provide the animal with food, veterinary care, drink, air, space, shelter, protection from the weather. There's a current penalty that is on the books that says that if you violate 10604, believe that carries a penalty of 90 days, if my memory serves. If what the bill would do is it would say you can't do those things I listed in 10604 and have the animal die. So if the animal dies and you did one of the things I listed in 10604, the maximum penalty is a year and a $5,000 fine. And as a condition of sentencing, a defendant convicted of violating the section, the court can order the defendant to participate in and pay for psychological treatment and pay for costs related to removing, housing, treating, or euthanizing the animal. And so that is what the bill does as it is here. Before we did that part, as we were here today. Delegate Arakan.
Thank you, Mr. Chair. We were just looking at some of there was very limited testimony on this side. Do we know what the impetus for this bill was? Did he mention that?
I think the idea from Senator Kramer is you have what are lower level animal cruelty cases that carry the lower penalty, but sometimes that consistent behavior goes on for long enough that it results in the death of the animal.
Okay.
But it doesn't rise to the level of animal abuse, which is the more serious crime that carries a higher penalty yet again. So the idea is to find an intermediate step, according to Senator Kramer, in between what we have and the next level up.
Okay, so the animal would have to have died for this bill to have any impact.
Or it can be euthanized.
Yes, either die or have to be euthanized, yes.
Okay, because I was like, I think sometimes
It
when
also
people
includes
transport
livestock.
animals, they don't, sometimes when you transport livestock, you don't feed them right before because it can make it an unsanitary living condition. It's worse for the animal because they'll defecate and stuff like that. So, but this is a death of an animal is required for this to take effect. Okay.
So it does require something more. Don't think we've had an animal bill yet this year, so. Oh, I'm sorry, we had Buddy's Law. Oh, Buddy. We're trying, no, he didn't forget. He didn't forget. Oh, dear. Are there other questions? Okay, I literally cannot do everything and get you all support dogs. Delegate Cardin.
Move the emergency status of this bill?
So for the record, this is listed, and the sponsor of the bill is somewhat unhelpful as to finding out why this is an emergency bill. But as it came over from the Senate, it's an emergency bill. So it's a little flummoxing, so we'll see if it actually gets 85 votes, but it'll be fun to watch. Delegate Taylor has a question then.
A2 talks about the need for a second opinion, and I just wonder if
Discuss this.
that's not, we did discuss this, isn't this?
We did discuss this and the cost it would be.
Isn't this?
Where are you? I'm sorry.
This is Senate Bill 80, right?
Yes.
Making sure I'm right. Okay, A2, page 3.
A person may not commit a violation of 10604 of the section that results in the death of a domestic animal or livestock, or the need to euthanize a domestic animal or livestock based on the recommendation of a licensed veterinarian if the decision to euthanize the domestic animal or livestock is validated before or after the euthanasia by a second licensed veterinarian.
How do you do that?
I think that is a valid question, Delegate Taylor. The Vice Chair.
I mean, I'm not saying I know how it's done. I will just say that the whole point is because there is euthanasia, and they want to be able to say that it was caused by X, right? To be able to punish someone, but it has to be caused by X. And they want a second opinion basically because they don't want it to be just me, the animal owner, wanting to euthanize my dog and then later blame somebody else. I could see that scenario, if that makes any sense.
I'm just thinking, you know, how it plays out, right? If I have I'm going to say a horse that is dying, apparently, and in order to prevent further suffering, you might want to get it euthanized as quickly as possible. You know, you could live in a rural community where there's only one veterinarian. I mean, does it not apply if you can't get the second opinion, or could we?
I guess in that situation where you have an animal you'd have to demonstrate that the animal was overloaded, that they were deprived of sustenance, that there was unnecessary suffering inflicted. You've got to do one of those first parts in the animal abuse statute at 10604, and it's because of that they died. If you were caring for the animal, you were getting regular veterinary care for the animal, you're doing everything you needed to do for the animal, and you reach a point where the rainbow bridge is in sight, then I don't think this wouldn't apply, because it's not that you were abusing the animal beforehand. You were caring for the animal, but you just reached a point where they need to go across the rainbow bridge, using the legal technical term.
I appreciate
Not making light of it. I mean, I think that is the distinction here. Now, as for the second veterinarian, I don't have very many answers about that, but I'm going to go to Delegate Erickson and then to Cardin. Let me do that.
Yeah, so the way I'm reading it is that because there's an or there, so, you know, it means either the animal dies, which is totally legitimate if an animal dies, but it really is hard to find large animal vets. And so if I call my vet out to euthanize my animal, there's no way I'm waiting to try to find a second. I mean, that could take days for another. I mean, so we're having an animal just suffering and suffering and suffering. So to avoid me being charged with this crime, I have to wait for a second vet to come out and say, yeah, that's good. That's a good idea. You should put that animal down, and it's not your fault. It's not because you starved it. Like, that's a lot of suffering for an animal. This is every animal. So every animal in the state would now be encompassed in this. So anyone who wants to euthanize a horse now, or any type of livestock, it says livestock.
Okay, so Delegate Cardin and then council.
I think I'm reading this that a person would be in violation of 10604 and could be prosecuted in such if it's euthanized and they assert by a second licensed veterinarian that in fact it needed to be euthanized because of whatever abuse was being alleged. It's not that you have to, you don't need two veterinarians in order to euthanize. You need to, in order to prosecute somebody for the violation of this, you need them to say that he had to be euthanized.
Okay, that is really the opposite way.
Okay. Thank you. Thank you.
All right, what's your pleasure? Motion for a favorable and a second. With the emergency bill. Best of luck to it. We'll hope that, it doesn't, hope that it doesn't see a rainbow bridge or something. All right. The vice chair.
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? She's out of the room. Schmidt?
Yes.
Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Dinette? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Conaway? Yes. Kaufman?
Yes, for Mr. Ed.
Yes, for Mr. Ad. Oh, dear. Williams? Williams?
Yes, I'm sorry.
Yes. Tolles?
Yes.
Yes. All right, the motion is adopted. We will see you all on the floor. This has been a voting session of the House Judiciary Committee. Thank you very much.